Today we'll talk about freedom of the press. Two of its aspects, the freedom to access information and the freedom to circulate content. So we've had discussions on these in some cases previously, but today we'll be focusing on its effects on the exercise of profession. How journalists, reporters can go about um, covering events, doing their work. And we'll have a particular segment how they can go about their work in the context of judicial proceedings or the relation with the courts or the judiciary. So there are very few regulations on practitioners. This seems to recognize that the right to speak, the right to express, the right to be heard is the right of everybody. Okay? Not just practitioners or not just licensed individuals. In fact, so it's clear that there is no board examination required for members of the profession. So any of the graduates of the College of Mass Communication. There are 46 professions regulated by the PRC, one by the Supreme Court. Unless you go into any of those particular professions, then there is no board or licensure exam that you need to pass. In practice also, there is no, generally, no registration or accreditation requirement. And in fact, you can use your employment ID as a media ID. Now, there are just some instances, some areas, some coverages, some dates that require accreditation. As to time, during the ECQ, the IATF required IDs for free travel, free passes. Kasi everybody was supposed to be at home. Now, they asked the PCOO to accredit or to give media these passes during the ECQ this year and last year. For foreign media as well. So can foreigners practice their profession in the Philippines? Clearly, yes. But there's just a request, a requirement that they coordinate with the International Press Center. What if they refuse to coordinate or do not get an ID? Uh, the, the penalties do not appear to be as heavy or um, as as punitive. However, it could be basis for revocation of a visa. Anyway, we haven't had such a circumstance. Mukhang lahat naman ng foreign media dumadaan sa IPC or they go about unreported. We've already talked about special events that have pre-registration, but there are instances like the papal visit, SONA, which require registration and accreditation because of the location and the sensitivity of the activity. So the objective of this accreditation or registration would be generally order. Now let's go back to the issue of the IATF registration or the IDs. So they required media to register from the PCOO or PIA, Philippine Information Agency. Now, at one time, the IATF flagged down someone with a media ID who turned out to be the publisher of a newspaper. Bakit yung publisher ang gumagala samantalang ang objective ng ID would be so media can freely cover events even during the ECQ. Ang issue nun, bakit parang nagamit pa yata yung ganitong exemption para mang-abuso yung mga tao. And in fact, there was a lot of discussion or a lot of reports about IATF IDs being forged, fake, but that's another issue altogether. Now, as regards PCOO or PIA, so this is one of the first times that we've heard about them. It's because they're not a regulatory agency, which is precisely why the NUJP at this time made a statement against such system, saying that the PCOO or the PIA should focus on government communication and information dissemination, not regulation. So, points for you to ponder. Do you agree or disagree with this kind of system? There are two particular instances that I found which generally go into regulation of print for student journalists, for student publications, and for radio. So the Campus Journalism Act states that the school will organize or will select the editorial board of any student publication. After the selection, the editorial board, the EIC, and uh, his or her staff can go freely about producing content. However, the Campus Journalism Act also says that the school can appoint a faculty advisor who will supervise the production of content or the production of the publication. On a logistical matter also, schools are or supply or must collect publication fees. There have been some instances when publications themselves, so yung editorial board, they go out during registration period and collect these fees themselves from the students. However, it seems to be a very cumbersome activity, no? So, kung ikaw talaga yung maniningil, baka malusutan ka o kaya ang hirap naman ng paglikom ng pera, etc. And also, it depends on kung gaano kasipag yung editorial board mo. That's why there's questions of sustainability and logistical feasibility of such system. But it could be done para lang ma-isolate or mahiwalay pa talaga yung student publications dun sa school, ma-insulate kumbaga. Next, there's also radio. Radio has an industry requirement of KBP accreditation. Ito yung para sa mga magsusulat o kaya maririnig on air. It's peculiar to note that KBP is not a government agency and that this is a commitment by industry practitioners, by the professionals themselves. It's a kind of self-regulation. All right, let's go on to the cases. So we had first ABS-CBN versus NTC, and the point of ABS-CBN is just that ABS-CBN has no congressional franchise as of now. So it cannot air on television or on radio. However, has it affected the ability of ABS-CBN to produce content? Seemingly no. So it continues to air, albeit on a different platform. To briefly discuss the case, no. So in ABS-CBN versus NTC, ABS-CBN went to to the Supreme Court, saying that it deserves or it can still air on television while its congressional franchise is being discussed in Congress. At that time, hindi pa naman na pagpapasyahan. So, under discussion pa lang. Sabi ng ABS-CBN, total Congress has the plenary power to grant a franchise. Then, meron siyang parang residual or corollary power to define the rights, preserve the rights and obligations, pending its final determination of the matter. Kumbaga, status quo ante. Things remain as they are hanggang hindi pa tapos yung usapan. However, the Supreme Court said that what's clear is you do not have a franchise. So the franchise of ABS-CBN lapsed in May 2020. So, ang sabi niya kasi, yung franchise niya sana after May 2020 would be sort of a temporary franchise or temporary permission to go on air. Sabi ng Supreme Court, there is no such thing. It's either you have a franchise or you do not have one. That's why they rejected this argument or this theory of yung corollary powers, and they rejected also the fact that the NTC had authorized ABS-CBN to have a temporary franchise from NTC. However, that's just half of the twin franchise requirement. And ultimately, this case was dismissed on mootness. Meaning, hindi na kailangan pagpasyahan kasi kalaunan, hindi na rin naman talaga nag-grant yung franchise ng ABS-CBN. But, as you can see, ABS-CBN continues to air online. So, that's another matter altogether. If online platforms can also or should also be regulated. Now, the case of Gauthier versus Canada, it's a UN case. So, a Canadian publisher, journalist, went to the UN saying that Canada, the country, violated Article 19 of the UDHR, the Universal Declaration. As a country, it failed to uphold his right to information. So Gauthier was denied accreditation as accredited media, in Parliament. So, but he was given a temporary pass. However, of course, it has limited privileges, and he was denied access on the same terms as other reporters and publishers who were permanent members of the organization in Parliament. Okay. Argument naman nitong si Speaker of the House of Commons of Parliament. Sabi ni Speaker, I can control the accommodation and services in Parliament. Okay? And that I have the authority to grant or not grant these passes. Okay, first, the committee said, the UN said, yes, you have the power, sabi niya kay Speaker of the House, you have the power to to regulate access to Parliament, to protect parliamentary procedure. That kind of protection, legitimate goal of public order. Therefore, an accreditation system, justifiable. However, it must be shown that this restriction is necessary and proportionate to the goals in question and not arbitrary. Meaning, the criteria should be specific, should be fair, should be reasonable, and the application should be transparent. So in the instant case, even if the Speaker of the House had such power to regulate access to Parliament, it failed to show fairness and reason in denying the application of Gauthier. Kaya, the fact that Gauthier was simply a temporary member of the Canadian Press Gallery Association and not a permanent member without reason or without explanation was a violation of Article 19 of the UDHR. So that is now considered as state obligation. Okay, so now that we're into banning or allowing reporters into the gallery, let's come closer and
Pinagbabawalan po ng
listen to this news clip about Malacanang banning Rappler reporters.
cover sa loob ng Malacanang Palace ang reporter ng Rappler na si Pia Ranada. Kanina, hinarang siya ng Presidential Security Group pero pinapasok din kalaunan pero hanggang sa new executive building lamang siya pinayagan. Sabi ni Presidential Spokesperson Harry Roque, hindi na siya maaring mag-cover sa Malacanang kung saan ginagawa ang ilang aktibidad ng Pangulo. Binawi na rin daw ang accreditation ng Rappler sa Malacanang Press Corps. Mag-apply na lang daw sila sa Foreign Correspondents Association of the Philippines o FOCAP dahil isa raw silang foreign-controlled entity. Matatandaang magpasya ang Securities and Exchange Commission na bawiin ang Certificate of Incorporation ng Rappler dahil sinuway umano nito ang batas na ang isang mass media company ay dapat kabuang pagmamayari at kontrolado ng mga Pilipino.
So as a foreign-controlled entity, they can certainly report under FOCAP. So we're not even curtailing their freedom of the press because FOCAP, foreigners can report from the Philippines. A second alternative is for them to seek accreditation from Mocha Uson, but I don't think they would want that.
Sa isang pahayag, sinabi ng Rappler, hindi raw maaring kanselahin ang kanilang accreditation na mag-cover sa Malacanang dahil hindi pa naman final at executory ang desisyon ng SEC. Hindi rin daw dapat gamitin ng gobyerno ang kapangyarihan nito para harangin at maiwasan ang pagsusuri ng publiko.
Okay. So now let's have the case of Filipinas versus Ago, where which involved a libel case against a broadcasting network in Bicol. So, Rima and Alegre hosted a radio documentary program titled Expose. So, it is owned by over the radio DZRCAM. So, this radio station was owned by Filipinas Broadcasting Network. Now, Rima and Alegre, our hosts, they exposed various alleged complaints from students, teachers, and parents against AGO. So, AGO Medical and Educational Center, Bicol Christian College of Medicine. So, Filipinas, the broadcasting network, versus AGO, the school. Claiming that the broadcasts were defamatory, AMEC and the dean of AMEC's College of Medicine filed a complaint for damages against Filipinas and the hosts. Now, in the decision, the Supreme Court said that, so eventually the hosts were held liable for libel. What's important for us is the discussion on the radio code. So, in this case, the court said that, okay, the broadcasts failed to meet the standards prescribed in the radio code. And it's the radio code that lays down the code of ethical conduct governing practitioners in the radio broadcast industry. And again, no, it's a voluntary code of conduct. Okay. It is a public warranty by the industry that radio broadcast practitioners are subject to a code by their conduct and are measured for lapses, liability, and sanctions. Remember that radio is in a peculiar situation because it's harder to censor radio kasi it's really live, on air, there are no editors. That's why the public has the right to expect and demand that radio broadcast practitioners live up to a code of conduct for their profession. And it must measure the standards uh, for broadcasters to see if they acted justly, honestly, good and with good faith in the exercise of his rights and performance of his duties as required by the Civil Code. This professional code of conduct also provides the standards for determining whether a person who willfully causes loss or injury to another has acted in a manner contrary to morals or good customs under the Civil Code. All right. So we go now into the rules on administration of justice. So how reporters can cover judicial proceedings. Okay? There are many rights at play here, including many constitutional rights that affect the right to information and the versus the right of the individual or the accused to privacy and to due process of law. So, on another question, do you agree or disagree? Which right or which freedom is above the other? So, is liberty of the press is subordinate to the independence of the judiciary? in the proper administration of justice. Okay, points to ponder. So first, let's go through the rights in criminal prosecution. Everybody has the right to be presumed innocent and are entitled to due process. That's according to our Constitution and the rules of criminal procedure. We, all people, are entitled to their Miranda rights, the right to be informed of the charges against them and to be informed that they have the right to secure a lawyer, um, to defend themselves and to keep silent so that they do not incriminate themselves. Generally, people have the right against vitiation of free will, uh, against self-incrimination again, and against extrajudicial confessions. Yung aamin ka na ikaw ang gumawa outside of the courtroom. Okay. We'll have a few cases on that a bit later. And of course, everybody has the right to a speedy and public trial. All right. Now let's go into these extrajudicial confessions as made in the case of People versus Andan and People versus Hipona. In People versus Andan, a student was raped and killed by a person who well, actually he was a stranger who had invited her into his house. Now, it turns out many people also lived in that house. So the following day, when they found the body of Marian and saw blood stains on the wall of the pig pen in the backyard, naturally they were so shocked by this kind of crime and tried to locate Andan, so the accused. So sabi nila, mukhang ito, among all those who lived in the house, mukhang ito yung gumawa. And they traced Andan to Bulacan. And there, the mayor cooperated with authorities. And in fact, he was the one who brought out Andan to the police headquarters where he was interrogated. Okay. Now, by that time, people and media were already at the police headquarters. So they were awaiting the results of the quote-unquote interrogation or investigation. Now, Andan, when he saw the mayor, he asked to speak to the mayor privately. Tapos sa loob daw ng kwarto, this Andan broke down and said, okay, Mayor, patawarin mo ako. I will tell you the truth. I am the one who killed Marian. The mayor opened the door of the room to let the public and the media listen to the confession. Nung una, nag-attempt pa silang, sige, kuha ka ng abogado umaamin Pero wala. Pero nevertheless, everything was photographed, videotape. Sinabi ni Andan kung paano niya pinatay si Marian, gusto pa niyang ipakita, saan niya dinala yung mga gamit ni Marian, humingi siya ng tawad, hindi lang dun sa biktima, kundi pati na rin dun sa mga kabahay niya na dawit-dawit na. Sabi niya, nagawa niya lang yon kasi puro dun sa mga nababasa niya na parang porno tsaka sa mga tabloid. Okay. At matapos nun, niyakap niya si Mayor, niyakap niya yung asawa niya at anak na nakarating eventually at sabi, tulungan niyo ako. Anyway, in court, Andan entered a plea of not guilty. Okay, and so what did the prosecution do? Use all the recordings of him admitting the crime in court. Okay, so first you had the confession to the mayor, and second, you also had the confession technically to the media. So, on the question of whether the admission to the confession to the mayor is admissible or can be used as evidence, the court said yes. So, even if, okay, the rule against extrajudicial confessions goes for law enforcement officers. So the police or the military. In this case, even if the mayor was parang chief of the police, so he had operational supervision and control over the local police, he was not the law enforcement officer envisioned in Article 3 of the Constitution. Therefore, hindi siya exempted yung confession sa kanya. Also, the confession did not come as a response to any interrogation. Walang katanong-tanong si Mayor, itong si Andan ang yumakap sa kanya at voluntarily malayang nagsalita at umamin. And kahit pa sabihin na nating uncounseled or walang abogado, maaari pa ring magamit yung confession ni Andan. Therefore, lalo na yung sa media. Okay. Actually, after the Andan admitted to the mayor or spoke to the mayor, he also addressed or talked to the media. At doon sa discussions niya or usap niya with the media, malaya din siyang sumasagot dun sa mga tanong ng media. In one case, in one instance, sinabi pa niya kung ano yung gusto niyang ipaabot sa publiko. Sinabi niya kung ano ang nangyari talaga nang hindi naman tinatanong or pinipilit. Kaya yung confession niya both sa mayor at sa news reporters who were not considered law enforcement officers and who were not considered interrogating or asking him questions and who were not clearly coercing him, these extrajudicial confessions were admitted as evidence. So, hindi covered ng Article 3 of the Constitution yung defense ni Andan in this case. In the case of Hipona, similarly, this was a rape case. Hipona allegedly raped and killed his aunt. So, tita niya. Tapos, ninakawan niya. Nagpatawag itong pulis, pagkatapos ng insidente, sa pag-iimbestiga, nagpatawag ng pulis ng meeting, kumbaga, ng tipon-tipon ng mga kamag-anak. Kasama na yung nanay ni Hipona, so yung kapatid nung namatay. Sabi ni Hipona sa nanay niya, "Mama, I am sorry. I did it because I did not have the money." So essentially, he was apologizing for the death of his tita. And yung mommy ni Hipona, signed an affidavit stating or recapping this confession. And it was on the basis of this confession that the police arrested Hipona. He was presented to the media, he apologized, but he qualified his participation in the crime. Sabi niya, look out lang ako. Ang totoong gumawa, meron kasing sinasabi sa kaso niya, yung co-accused ko. Okay. During trial, the accused, so Hipona, pleaded not guilty. The two accused. So, hindi sila umamin. Tapos, yung nanay, remember, si mommy, signed an affidavit recapping or reiterating the confession to her. She refused to take the witness stand. At pulis na lang ang nag-testify as to her declaration. Kaya, yung ginamit ng court to rule was this is a type of evidence, circumstantial evidence, kumbaga hindi direct evidence. Circumstantial evidence na una, meron kasing natagpuan sa kanya na necklace. Siya yung may suot. Pagkatapos nung rape. Second, meron siyang sinasabing confession. And third, merong another radio interview siya day after his arrest na umaamin din siya. And all of these pointed to the conclusion daw na siya yung guilty. Take note that during this time, walang ginamit na object evidence or kumbaga walang CSI evidence to point that he was the accused. So it's either in rape cases, it would be semen, that the semen taken from the body of the rape victim came from the accused, or blood samples, DNA, or hair, may naiwang bakas, etc. Wala. Ito lang talagang confession niya. At yung fact or yung circumstance na nasa kanya or suot niya yung necklace nung napatay. In this case, the court still found him guilty. With regard to the confessions to media, these could be admitted as evidence, citing Andan. So yung confessions were made in response to questions by the media, not by the police or any investigating officer. So these statements also were spontaneously made. Now there was an issue, now this is very specific, there was an issue about the statement that he made on the radio show. So he was asked by the radio reporter, why did you do it to your aunt? Okay. Sagot niya, because of my friends and peers. Tinanong pa siya na baka naman lasing ka o kaya nakadroga. Inulit niya lang na he did it because of his friends and of poverty. Anyway, the court said, even if the question was vague, tapos parang leading, it did not even specify what crime was being referred to, anong ginawa mo, bakit mo ginawa yon. Sabi ng court, pwede mo naman ilinaw yon during the interview kung may pangailangan. Pero, hindi mo ginawa. Kaya, kumbaga, kasalanan mo na rin yon. And eventually, after everything that you put out on air, the accused did not take the witness stand. So he failed to controvert these statements that were on record. Kaya the court took it against him and affirmed his conviction. So the moral of the story is media should really be careful when covering these kinds of events because your coverage, your footage, your news reports can be used as evidence in court against the interests or against the rights of the accused. So, sa isang discussion ko, turns out, I was discussing the case of Andan before a reporter who had covered the case and in fact was one of those who took the stand in that case. And he remembers clearly how the accused came up to him and disclosed all these instances. And he said that it was a surreal experience. However, he was there simply as media to capture what was necessary. Of course, it's another matter, yung issue tungkol sa sensationalism of media, of news. But then, he has a valid point in the sense that he was only there to cover the events, except that, of course, some reporters have this tendency to prod further at papaaminin ka talaga on air. Let's see a few examples of this instance. Sikat na sikat or usong-uso yan dito sa Pilipinas, no?
Money earned from that. Kush 1.5 M per kilo. Maybe I can change the Philippines, like run for politics.
Dapat ay hindi raw ikinukulong ang mga gaya niyang malinis ang intensyon.
Advance ako mag-isip. Look at Antipolo. How much is the land area of Antipolo unused? Good for farming of marijuana. Marijuana can produce plastic that decays in 90 days. Marijuana can cure cancer.
Pero ayon sa Antipolo Police, putok na ang pangalan ni Albert. Kapwa raw niya call center agents at mga mag-aaral ang kanyang mga parokyano.
money earned from mag-isip. Land case in 90 days. Marijuana can cure cancer.
Pero ayon sa Antipolo Police, putok na ang pangalan ni Albert. Kapwa raw niya call center agents at mga mag-aaral ang kanyang mga parokyano.
Hindi siya nakalis pero ito yung tinatawag naming newly identified siya. Yung mga more on mga street pushing.
Emil Sumangil, nakatutok, 24 oras.
Ito, Duterte, mag-draw tayo. Mag-draw tayo. Bigyan mo ako ng baril. Sige. Walang problema. Ba't ako matatakot?
Ito ang hamon ng lasing na si June Calumpiano kay President-elect Rodrigo Duterte matapos siyang mahuli ng mga otoridad sa Oplan Disciplinary Hour ng Barangay Gulod sa Novaliches, Quezon City. Inireklamo siya ng mga kapitbahay matapos silang tutukan ng baril at kalaunay nagpaputok sa lugar.
Ako nahuli dahil lasing ako. Dahil sa kasalanan ko, nagpaputok ng baril. Ito, nahuli ako.
Saan galing yung baril mo?
Ay, binili ko. Bakit? Alam nga naman, hindi lisensyado yan. Galing yan sa illegal.
Narecover ng mga polis ang
Arestado naman ang isang lalaki sa Cubao matapos manloob at tangkang manggahasa. Pero pagmamalaki niya, sadyang hilig lang niya ang mga rape. Maaksyon si Amber Gonzalez.
Aminadong lasing at langus sa droga ang 25 anyos sa si Bethoven Del Mar Jr. nang mahuli ng mga pulis sa Cubao kaninang madaling araw. Sospek si Del Mar sa panloloob at tangkang panggagahasa sa isang babae.
Bago ako ngayon pumasok sa bahay na yun, nakadroga na ako, nakainom na ako. Ngayon, pinasok ko yung bahay, kumuha ako ng kutsilyo sa kusina, naghanap ako ng kutsilyo. Sabi ko, mo, pag hindi ka sasaksak ko sa ito, papatayin kita.
Di na raw kasi nga matiis ang tawag ng laman, kaya pinasok ang bahay.
Pag lasing ako, talagang tamang manyak ako eh. Talagang hobby ko, mang-rape talaga, man-rape.
Naabutan niya sa bahay ang...
Alright. Now, onwards with due process of law. So everybody has the right to due process, the right to equal protection of the law if they are similarly or equally situated. As due process also. So here are the evidentiary standards. So public records should be admissible. And what are public records? Those that are kept by public officials in the regular course of duty. Next, political history is a matter of judicial notice, meaning you don't have to prove it anymore. Technically, when you say political history, it's something that should be written in the history books, right? Say political history, you know. However, the way things work out, political history is contained at the moment in news reports. So this is where the duty of reporters, journalists, editors, and everybody who produces content, this is where their duty to report as accurately and as reasonably and as fairly as possible the events of the day. The duty to truth so that in the future we can appreciate our history more appropriately. And lastly, another standard of evidence, okay? Witnesses, when called to court, can only speak of their own knowledge. I cannot speak about something that somebody else said. This standard of personal knowledge guards against hearsay, which is something that the courts cannot admit. Okay, so first, we did discuss newspaper reports as part of history. Okay, so what is the evidentiary value of newspaper reports? Okay, first, let's have the case of Feria. In Feria, in that case, it was alleged that the accused had already been convicted of the crime of a robbery with homicide and before had already been sentenced to life imprisonment. The the prosecution said that this was enough evidence to prove his conviction. However, the court disagreed. Okay. So, newspaper articles actually amount to hearsay evidence. All right? Even twice removed and therefore not admissible. Bakit twice removed? First, who convicted or what is the proof of the conviction of the person? So, the fact of the conviction can be established by the judge repeating or reiterating to the court that he convicted this person because he was the one who did the act, or by presenting the conviction, the document, which was signed by him. Okay? So instead of him going to court and saying, oh, I convicted this person, this is what happened, these are the details, you can just present the document. And since it's a public document, it can easily be admitted in the records of the court. However, a newspaper report reporting on that will be once removed, right? A newspaper report reports on a document or an incident where the writer was not present in court. Okay. So when you get that newspaper report and bring it to court, all right, that newspaper report is the account of one person talking about the case or something that happened some other time and some other act done by another person. So, pasa-pasa na. Essentially, the court here said that news articles are chismis and cannot be admitted in court. And same goes as in the case of Karugal. In Karugal, there was a newspaper report that talked about a possible alternative suspect or possible alternative accused in this case. So the police tried to enter, the accused here tried to enter as evidence some news articles in actually tabloids, where it said that um, the where it said that another person killed the victim in this case, and this was heavily covered in the media supposedly, and allegedly again, no, recovered from this suspect, from this other person, was the missing firearm. So, nakuha sa kanya yung barel nitong biktima dito sa kasong to, isang pulis. However, the court again said that news reports are hearsay and cannot be admitted in court. They have no probative value. So, the accused in this case cannot use that as a defense by itself and needs to prove his own version of events rather than present an alternative version na kailangan pang pruwebahan. So, essentially, huwag tayong maniniwala kaagad-agad sa mga news reports. Of course, there's a question again kasi supposedly it is proof of political history. So we go to two other cases where the court had a different perspective than these two cases that we discussed, Feria and Karugal. Okay, Estrada versus Sanigan Bayan. Okay, in this case, sorry, let me correct that. This was the case of Estrada versus Desierto, who was the ombudsman at that time. So, I don't know if you remember Estrada, but he was the president who was ousted, was removed from power because of EDSA 2 in 2000. So it began in, January 2001. So it began in October 2000. So there were allegations of wrongdoings, including bribe taking, illegal gambling, other forms of corruption against Estrada versus the Senate Blue Ribbon Committee. Now, he was impeached by the House of Representatives. And during impeachment proceedings in the Senate, there were more serious allegations of graft and corruption. Pabigat ng pabigat yung issue hanggang isang araw pumutok, nagkaroon ng I accuse, tapos yung envelope na ayaw buksan, na na nagalit na yung mga tao and physically went out into the streets demanding for his resignation or his stepping down from power, simply put. So, technically, he left Malacanang on January 16, 2001. Oh, sorry. Okay. Sorry, make that January 20. So, as the people were gathered in EDSA, the PNP and the AFP also withdrew their support for Estrada. So, this echoed EDSA 1. And they had to get the Supreme Court declare that the seat of the presidency was vacant so that Arroyo will be sworn into office. Arroyo, his vice president, will be sworn into office in front of the crowd at EDSA. Okay. So eventually, Estrada had to leave Malacanang because there was a new president in power. Okay, now back to these cases. So, after his ouster, so ERAP was being investigated by the Office of the Ombudsman for the many cases and crimes that were alleged during the impeachment proceedings and other hearings and proceedings that involved him. And so, technically, even though in these cases, he wanted the Office of the Ombudsman to stop investigating him because he was president. Okay, that was his argument. Because he was president, he enjoys presidential immunity. Because that was his argument, therefore, the case necessarily went into, sino na ba talagang presidente? Okay. Ngayon, ito yung naging malaking tanong. Hindi na ikaw ang nakaupo sa Malacanang, hindi na rin ikaw nag-oath. Bakit mo nasabing ikaw ang presidente? And so, ERAP argues that he only temporarily gave Arroyo his seat and was anyway coming back. And so now, pabalik na ako. Ako na, babalik ulit ako bilang presidente. So, it was a tenuous argument, especially as to how he really stepped down from power and what really happened during EDSA 2. Okay. So in this discussion, there was the political question of, did he step down? So first, what are the elements of resignation? Did he step down? Did he resign? Did he what? So they said that, okay, let's consider this a resignation. And what are the elements of resignation? That you wanted to resign and that you made acts or did something to effect that resignation. So when Estrada left the palace, they said that's the act of relinquishment and the totality of prior, contemporaneous, posterior facts and circumstantial evidence. Totality of circumstances test. It said, it indicated that he left Malacanang and resigned or left his seat. Now, as to intent, okay, it's hard to go into a person's brain, especially if that person says, no, 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 I did not intend to resign. Okay, if there is denial on the part of the person. However, eto, papasok tayo dun sa mga nakapalibot kay Estrada. So, in this case, what the court used to look into the state of mind of the petitioner was the diary of his executive secretary, Edgardo Angara. Okay. In this diary, Angara talked about what he felt, what he observed, what he saw in the morning of January 19. So that was the day na sinasabing he resigned. So there, Angara reiterated or put down their conversation. So ang ina-attribute niya kay President Estrada then was, Ed, seryoso na ito. Kumalas na si Angelo Reyes. Okay? Also, Ed, sabi ni Angelo, I would have 5 days to a week in the palace. Nako, Ed, magtulungan na tayo para sa peaceful and orderly transfer of power, etc. So, because of these statements that were reflected and observations no, that were reflected by Secretary Angara, the court said that they saw or they found that Estrada had the intent to resign. And then there came the words as well. Pagod na ako. Ayoko na, masyado nang masakit. Pagod na ako sa intriga. I just want to clear my name and then I will go. So the court said, Estrada saying ayoko na is clearly indicative of his intent to resign. So now what's the implication of this? Ang Angara's diary was a second hand. So ano na siya, hearsay na siya. It was attributing words to Erap and observations to Erap. Okay, so Angara is the first parang hearsay, 1 degree. The Angara diaries that the court took into consideration were as published in the Philippine Daily Inquirer. Okay, in this case, what the prosecution used, what the ombudsman used, was clips from the news, from the Philippine Daily Inquirer. So this was, in a way, second degree. Kaya, nung pagdala nung ombudsman nito sa korte, it was so removed, it was triple hearsay, it was so removed from the speaker that it should not have been considered as evidence. But clearly, in this case, the court did not look into that, overlooked that, and accepted the Angara diary as printed in the Philippine Daily Inquirer as proof of intent. Now, in the case of Nuez versus Cruz Apaw, we had Cruz Apaw, who was the executive assistant of a clerk of court in the Court of Appeals. So she was a court staff who tried to solicit 1 million pesos from one of the parties in a case who was going against a government corporation. So, yung 1 million pesos na daw to, it will ensure you a good result in the case. Now, yung si Salvi, si Nuez, so it first went, so this is curious, no? There's a term already for this, the Rafi Tulfo brand of justice. So they went to investigador of GMA Network na tinulungan naman silang makapunta sa Malacanang, kung saan nagplano sila ng entrapment operation versus nitong court employee. During the entrapment operation, investigador was there. They were videoing the entire incident. In fact, one of their staff was introduced as her companion. In this case, so there was an issue as to whether this was an entrapment or an instigation. An entrapment is something where the accused would have just proceeded with the crime even without your participation. However, as again, the court did not note or even censure the TV crew that participated in that entrapment operation. On the other hand, an instigation is when you participate in the crime, meaning ikaw yung nagko-compel dun sa tao na i-commit yung crime. Otherwise, he or she would not have committed that crime. Okay, on the next point. So, judges should be independent, free from extraneous influence, pressure, indirect or indirect from any quarter or for any reason. This is in their Code of Judicial Conduct for the Philippine Judiciary. I had one such case where this was invoked. Most recently, the case of Lady Ann Salem journalist who was arrested on trumped-up criminal charges. After we successfully argued for her release, okay, this tarpaulin came out. And it had the implication or the insinuation that Judge Kisumbing Ignacio, who ruled to or ordered the release of Lady Ann Salem, it insinuated that she was in favor of or in contact with or in cahoots with the Communist Party of the Philippines. And supposedly, the government claimed that Lady Ann Salem was a member of this organization. So clearly, it was one, a case of red tagging, and two, a case of pressure. However, curiously, the Communist Party of the Philippines, the NPA, and the other organizations that allegedly printed this, no, they disclaimed and said that, oh, we did not print such tarpaulin. So, as to the question of who created or who put out this tarpaulin, still unsettled, but clearly there was an attempt to influence or to pressure the judge. Iniipit nila kumbaga si judge sa isang bagay na hindi naman totoo, that one, and second, more dangerously, iniipit nila si judge sa isang circumstansya kung saan the danger with red tagging is this, kung saan the consequences can be as dire or as serious as death. So when you're red tagged, in many instances, these personalities end up dead or in a order of battle or list of persons to be killed. All right. So let's talk about prejudicial publicity. This is what goes into this topic. So prejudicial publicity. So in People versus T. Hanky, you had a respondent, so T. Hanky, who was the son of a former Chief Justice of the Philippines. And he was convicted of murder and fatal and frustrated murder for the killings of 3 persons. So on appeal to the Supreme Court, one of the contentions of T. Hanky was that the publicity that was given to him was so massive, it was so overwhelming and prejudicial that it effectively denied him of his right to an impartial trial. So essentially, he blamed the press for his conviction. He cited the case of Estrada, Drilon, he cited the statements of high government officials, including the president, who visited the victim, si Maureen Holtman, so this was the case, while she was in the hospital. And so he said that the trial judge failed to protect him. Okay. From all forms of prejudicial publicity and disruptive influences. There were so many things that was happening at that time, and that he felt that dehado siya all the way. Now, he went up to the Supreme Court on this question, whether he was denied due process, denied the right to a fair trial. Now, the court said, okay, totoo. Okay, totoo naman na ang laki ng coverage sa'yo. It was so pervasive as with all other high-profile and high-stake criminal trials. So, nangyayari naman to talaga sa Pilipinas. However, so here's the most important thing about the case of Tihanki. Pervasive publicity is not per se prejudicial. Hindi porket nako-cover siya every day, it does not prove na the judge ruled improperly or unfairly. So, ang isang judge, hindi siya parang ermitanyo na nakatago sa isang kuweba o nakatago sa bato at walang naririnig, walang nakikita. What's important is kung yung naririnig ba niya or nakikita niya ay nakaapekto ba sa kanyang partiality. So in these cases, in these kinds of cases and allegations, we have to apply the totality of circumstances test. in Webb versus De Leon, which was the case, the Visconde massacre. So Webb claims that he had undue prejudicial publicity. But in this case, Webb filed or asserted this claim while the case was still being investigated or undergoing preliminary investigation by the prosecutors. So he said that during their preliminary investigation, the attendant publicity deprived them of the right to fair trial. Eventually, this case went up to the court, and he also alleged the same. Following the ruling in other cases, the court dismissed this argument, saying that if you want a finding of prejudicial publicity, you can't just say that the media is covering you too much. You must allege and prove that the judges have been unduly influenced, not simply that they might be. So parang you have to prove the what happened, what is, not what could have been. Okay. So in this case, they found nothing in the records to prove that the tone, content of the publicity fatally impaired the fairness and impartiality of the DOJ panel. And then also, in relation to the next case in Estrada versus Desierto, okay, the case was being investigated by a DOJ panel. Okay, so it is composed of an assistant chief state prosecutor and senior state prosecutors. So marami sila. You have to allege that all these persons or any of these persons na most responsible for the decision was influenced. Naging issue, kumbaga para sa court na, kung sinasabi nyo palang isa sa kanila or lahat sa kanila ay epektado yung partiality, bakit hindi nyo pinadisqualify on the ground of bias? Okay. Now we go back to the case of Estrada versus Desierto. In that case, again, it was also a case under preliminary investigation under naman ng Office of the Ombudsman. Okay. So the team that was investigating or looking into the cases in the Office of the Ombudsman included several members of the Ombudsman team. Kaya lang, ang leader nila, ang head nila was Aniano Desierto. The court said that even if Aniano Desierto is the head of the Office of the Ombudsman, if he is not the one who is investigating or deciding on the case, then you cannot say that any bias gleaned from him radiates or flows also to his subordinates. So remember that Estrada filed these cases or was charged with these cases after he stepped down from power, and that he filed these, itong mga Estrada versus Desierto, itong mga counter suits, after he had stepped down as president and when a new administration was in power. So Estrada was on the other side of the fence, ika nga. And so he said that the Office of the Ombudsman, being part of the administration at that time of Arroyo, was clearly against him. The statements and allegations that he attributed were to Aniano Desierto as a person. So in this case, the court warned or said that there is no such thing as a derivative prejudice. Just because this one person, the head of the agency, is against you, doesn't mean that his subordinates who will be deciding or who are investigating the case will rule against you following the not following the instruction, but following the cue of his superior. It's another thing entirely, no? Kapag sinabihan ni Desierto, i-convict nyo yan, i-ensure nyo na may finding ng probable cause nun. But you have, again, to allege that clearly. You have to show evidence that this person really has bias against you. You cannot just use hostile headlines or news reports to show na incapable na yung judge to rule fairly. Now let's have the case of Shepard versus Maxwell, one of the biggest cases of that time in the US. Okay. So in this case, the pregnant wife of a doctor in Cleveland, she was a prominent socialite, so mayaman sila, she was beaten to death. Her husband, so si Shepard, who is the petitioner in this case, tumawag siya ng maraming tao, ng mayor, ng kaibigan, to report the crime. Originally, ang sabi niya, may intruder. May pumasok daw sa bahay niya, tapos knocked him out. So, immobilize siya. Hindi niya na alam paano nangyari. But then the police found no signs of breaking and entering. And so, the inquest was biased already against the doctor, and it was the press who goaded the government, the prosecution, to charge the doctor. It was so intense. They noted that one newspaper ran 399 stories in 6 months about the Shepard case. Now, when the case went to trial, it seems as if the judge allowed the media free rein. So it included, he allowed the publication of the addresses of the witness, photos of the 12 jurors. Tapos, yung nasa front seat pa kapag hearing, press, radio, TV. So, ang daming chismis, ang daming nire-report that were supposed to be taken as credible evidence. And this is dangerous, no? At one time, the judge was quoted by a columnist saying that si doctor was, quote-unquote, guilty as hell. So, sobrang daming nangyari, sobrang gulo. And Shepard used that to assert that he was not entitled or was not given a fair trial. So, all the time, he maintained his innocence. Tapos sabi niya, the judge precisely failed to protect him from the massive, widespread, and prejudicial publicity. When he went up to the Supreme Court, the court agreed. Okay. Sabi ng Supreme Court, okay, that freedom of expression should be given great latitude, but hindi ganun ka-broad, no? Especially if it's court proceedings. It cannot divert the trial away from its primary objective, adjudicating both criminal and civil matters in an objective, calm, and solemn courtroom setting. So, yung coverage niya was so intense. He was caught on cam detailing crimes that he was later charged with, different crimes altogether. The trial was blatantly hostile. Even yung physical arrangement of courtroom, yun nga, yung placement, yung front row seats for the media, it all facilitated or it all went into a seeming collaboration between the prosecution and the media. Altogether, it shaped the jurors' minds that he was guilty already and that, therefore, Shepard was denied fair trial. The Supreme Court said or suggested that the trial judge should have either postponed the proceedings or transferred them to a different venue. In any case, the Shepard murder went into retrial, but the doctor was acquitted. In that case, they already restricted media. But however, nakapag-upo ng forensic witnesses. So, this time around, they did not depend on testimonial evidence, mga chismis, or things based on what was said or written, but something that was objective. So, they presented a doctor, they were able to present several other pieces of evidence. Eventually, The case, oh, so Shepard was acquitted. Okay. If you would like to further imagine what happened in this case, you can just watch the movie The Fugitive. Okay, this was a retelling or a fictional imagination of what happened in this case. Okay, so now let's go to media coverage of trials. We've said time and again that there is the right to public information. And of course, there's still the right to a fair and public trial. And to balance this, courts generally do not allow live coverage, meaning you may set up ng camera, tapos may crew, because it diminishes the dignity and solemnity of the proceedings. Parang may shooting, di ba? In fact, no person can record the proceedings, whether photo or video. Okay. But the public can be present, and part of the public is media. Okay. Let's have the case of the Ampatuans, and let's have two video reports of how the court allowed live media coverage of the decision on the Ampatuan case. And it would be interesting to differentiate these two reports. One of these comes from News 5, TV5, and the other comes from PTV4. Note the change in tone, the change in subject, the change in object. Okay, so let's see how you can analyze these two pieces of news reports.
Pinagbigyan ng Korte Suprema ang hiling na live media coverage sa pagbaba ng desisyon sa Maguindanao Massacre case sa December 19. Ayon kay Supreme Court spokesman Attorney Brian Keith Osaka, ang PTV4 ang magkakaroon ng access sa dalawang kamera sa loob ng courtroom. Pero obligadong state TV company na ibahagi ang live footage sa lahat ng mga pribadong news organizations. Gagawin ang promulgation sa Camp Bagong Diwa sa Taguig City. Higit 10 taon nang nakakalipas ng tambangan ng convoy na maghahain ng kandidatura ng Noy gubernatorial candidate na si Toto Mangundo Datu. Kabilang sa 58 nasawi ang 32 miyembro ng media.
Live coverage ng pagbaba ng hatol sa Ampatuan Massacre, pinayagan na ng Korte Suprema. Ang sentro ng balita niya mula kay Mark Fetalco, live.
Angelique, bilang government channel, inanunsyo na ng Korte Suprema ng PTV4 ang mangunguna sa live media coverage ng promulgation ng Ampatuan Massacre case. Ayon kay Supreme Court spokesperson Brian Hosaka, 2 kamera ang set up sa loob ng courtroom at tayo, Angelique, ang PTV4 ang may control dito at under supervision ng SC. Pero papayagan naman aniya ang lahat ng media outfits, kabilang na dyan ng foreign correspondents na mag-hook up sa PTV4. Dahil naman sa limitadong espasyo ay tanging mga accredited reporters lang ang papayagan na makapasok sa loob ng media room kung saan mag-set up ng wide TV screen para mapanood ang buong proceedings sa loob ng courtroom. Bawal din ang cellphone, camera, recorder o kahit anong recording gadget maliban lang sa equipment ng PTV at ng Supreme Court. Asahan din aniya ang ilang security checks bago makapasok sa courtroom. Samantala, pagkatapos ng promulgation, agad namang i-upload sa website ng Supreme Court ang kopya ng desisyon sa Ampatuan Massacre case na itinuturing na pinakamalaking election-related violence sa kasaysayan ng Pilipinas. Nakatakda namang ilabas ng SC ang resolusyon ng guidelines hinggil sa media coverage ng Ampatuan Massacre case sa katapusan ng linggo. Angelique, nakatakdang isagawa ng QC-RTC Branch 221 na pagbasa ng sakdal sa December 19 sa Camp Bagong Diwa sa Taguig City. Dito inaasang hatulan na ang nasa higit 100 individual na naharap ngayon sa kasong murder dahil sa pagpatay sa 58 individual kung saan 32 dito ay mga mamamahayag. At yan na muna ang latest mula dito sa Maynila. Mark Fetalco para sa Bayan.
Okay, as you can see, syempre kailangan bida yung PTV4 sa balita nila. Oh. Syempre sila ang government agency or media organization that was given authority to produce the live broadcast. There are other clips as well, pero if you would notice as I've noticed, the one from Rappler, the one from ABS-CBN, hindi importante kung sino magbo-broadcast. Ang importante, na-broadcast. Okay. These are the guidelines as referred to in the news reports. So it could be for live broadcast or documentary purposes. And as was stated, media have to be accredited because of space restrictions. Now, here's the thing. With live broadcast, walang cut-cut, walang zoom-zoom, walang special anything, walang focus, etc. It just has to be a stationary camera, and the broadcast will have to be continuous and edited without commercials. This, of course, is one of the exceptions to the general rule nga na sinabi natin na courts or court processes should not be do not allow media coverage. So in that decision, in that resolution, the court noted the use of technology should help law in furthering administration of justice. Okay, so hindi magkaaway dapat ang technology at ang media, in fact. Now, let's compare that with the Estrada trial live coverage guidelines, where live coverage or live broadcast was not allowed. In this case, the court said that it should be for documentary purposes only. Same regulations, though logistically there should be the cameras should be installed inconspicuously, and note this was in 2001. Bulky pa yung mga cameras nun, malaki, tapos may TV crew ka pa talaga. Kaya ang sabi nila, it would be not feasible also to transmit to one tapos yung sharing. Kaya kung ano't ano man, this recording will only be for documentary purposes. And logistically, ang ano rin nito, that if in the Ampatuan trial, it was the PTV who was in control. In this case, it was the Sandigan Bayan who should be in control of the recording. And this was what was stated in that same resolution. Why live coverage was not allowed? Kasi, again, going back to the Estrada plunder cases, this was after he had stepped down as president, no? The scrutiny was so intense, and it almost felt like a witch hunt. Kasi at that time, of course, he was again on the other side of the fence. Hindi na siya yung nagaharing uri, or hindi na siya yung nagaharing the ruling party. Okay. So the court in this case said that okay, hindi pwedeng live coverage kasi baka kung anong mangyari. Remember, we just came at that time from EDSA 2, which actually was a live which was one of its impetus was the live coverage of the trial at yung ayaw buksan yung isang envelope. Kaya sabi nila, baka magkagulo na naman, okay? Kasi live na nalaman ng tao kung anong nangyayari. Pero sabi din ng court, maganda din na alamin natin kung ano yung nangyari for purposes of discussion, for history. And so, this is why we cannot allow live coverage. There is a possibility that the judgment in these cases will be rendered by the popular tribunal before the Court of Justice can render its own. Okay, and now let's look at something that I would like you to think about.
Lumulutang sa social media ngayon ang iba't ibang opinyon at espekulasyon tungkol sa Dasera case. Ang sabi ng ilan, tila trial by publicity na ang nangyayari. Unang nagbabala ang grupo ng mga abogado at law students sa danger ng trial by social media dahil parang nababaliwala raw ang legal proceedings.
Let's say nagkakameron na agad ng resulta sa mata ng tao o sa mata ng karamihan kung ano nga ba talaga ang nangyari. When in fact and when in law, hindi pa naman talaga napapatunayan kung nangyari nga ba talaga ito or hindi.
Paliwanag ni Atty. Dicini, nandyan ang panganib na magkaroon ng bias ang publiko dahil sa mga lumalabas na espekulasyon.
ang nangyayari dito sa Dasera case is wala kasi tayong impormasyon. So nangyayari ngayon, marami nag-speculate at of course may mga unintended consequences yan kasi hindi naman official yung opinions, yung iba pwede natin sabihin baka uninformed, no?
Isa pa sa danger na nakikita ay ang pressure na ipinapatong ng publiko sa mga otoridad para sa agarang pagresolba ng kaso. Kaya't binigyan din ito ang halaga ng due process.
So medyo mahaba yung proseso ng paglabas ng warrant of arrest. Pero of course, yan yung proseso na yan yung nasa batas eh. Pero sa mind kasi ng tao, ang gusto nila, pag may maling nagawa, immediately arresto mo na yan.
Sa pagdetermine naman kung anong kaso ang isasampa sa mga akusado, Fiscal's Office raw ang magdedesisyon nito. Sabi ni attorney sa Dasera case, forensic, physical at circumstantial evidence ang maaaring pagbatayan. Sa anumang kaso, sumalang man sa trial by publicity, ang patas na desisyon pa rin daw ng korte ang pinaka-importante.
Ang ideal, di ba, justice is blind. Kaya naka-blindfold, di ba? Para makapag-decide ka fairly, mas mabuti yung less yung input. So,
buo ang paniniwala nito na mananaig ang legal system ng bansa sa pagresolba ng kontrobersyal na Dasera case.